Welcome in to the final day of the 9th Annual Executive Branch Review Conference hosted by the Federalist Society's practice groups. I'm Dean Reuter, Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. Thank you all so much for being with us today. And welcome to the AirMeet platform, which will allow you to visit with friends and colleagues, speakers, and Federalist Society staff members in the AirMeet Lounge all day today, before, between, and after panel discussions. If you're not logged on to AirMeet now, you can still join using a few simple steps through the Federalist Society's website in order to take advantage of these networking opportunities. Our first panel this morning is on climate change and environmental justice. I'm very sorry and saddened to report that one of our panelists, Mr. John Cruden, suffered a family tragedy earlier this week and is not able to be with us today, though our thoughts and prayers are with him and his family at this time. We have been able to find a replacement for him, and we will carry on. Our moderator for our first panel this morning is Judge Joan Larson from the Sixth Circuit Court of Appeals, where she served since late 2017. Before that, she served as a justice on the Michigan Supreme Court. Before that, she was on the University of Michigan Law School faculty. She clerked for Judge Santel and Justice Scalia before a stint in private practice and in the Department of Justice's Office of Legal Counsel. Notably, I think, she graduated first in her class at Northwestern University Law School. Now, I spent some time myself at Northwestern Law School, but perhaps that was before they had class ranks. I'm not sure. Judge Larson, please go right ahead. You need to come off mute, Judge.
Yes. Thank you, Dean, both for the introduction and for the cue to come off mute. You can see that first in class didn't really help my technology skills, so I thank you. And I thank you for the opportunity to be with us, with you today. The topic of today's panel is climate change, environmental justice, and the environmental agenda. The new administration has promised an aggressive approach to environmental concerns and has made clear that environmental concerns will be a priority. The president, for example, has vowed to reduce carbon emissions by 52% by the year 2030. And the administration has promised a whole of government approach to climate change, meaning that every agency will have the environment and environmental justice as part of its brief. But will the administration be able to meet these goals, and at what cost? What exactly should we expect from the new administration in terms of climate, the environment, and environmental justice? We are lucky to have a panel of distinguished experts to help us think through these issues today. I will introduce them very briefly, but I invite you to check out their full biographies on the website. Our first speaker today will be Matt Leopold. Mr. Leopold is currently a partner at the law firm of Hunton Andrews Kurth. He comes to us with extensive experience in both state and federal government, having served as the general counsel of the EPA in the last administration and also as general counsel of the Florida Department of Environmental Protection. Next, we'll hear from Hannah Vizcarra. Ms. Vizcarra serves as a staff attorney in the Environmental and Energy Law program at Harvard Law School, where she leads the portfolio on private sector approaches to climate and environmental issues. She is both an experienced litigator and frequent speaker on environmental topics. Our third speaker will be Tony Francois, who is senior attorney at the Pacific Legal Foundation. Mr. Francois is also a seasoned advocate and frequent speaker on environmental and land use issues. He frequently litigates on behalf of individual landowners in their environmental and property rights disputes with the government. And finally, we will hear from Nadira Clark, who graciously stepped in to join the panel on short notice. Ms. Clark is a partner at Baker Botts and the section chair for the Environmental Safety and Incident Response. In addition, she has a wide range of experience in the U.S. Department of Justice, having served both as a federal prosecutor and as an environmental litigator at ENRD. A few housekeeping items before we turn to our speakers. If you are in the audience, you may send text-based questions through the Q&A tab. in the upper right-hand corner of your screen. There is also a chat tab, but don't use that to ask questions. Use the chat tab to chat with one another. If you want to ask a question, use the Q&A tab. You may also ask live questions by using the raised hand button. You will need a working microphone in order to use this option. So with those housekeeping items out of the way, I will turn it over to Matt Leopold to start us off.
Thank you, Judge Larson, for that kind introduction. As you've heard, I'm Matt Leopold, and I served most recently as the EPA General Counsel, focusing on regulatory development and a lot of litigation. I also served as an environmental litigator at the Department of Justice earlier in my career, and have been around a lot of administrative law challenges, and which could be very relevant for our discussion today. I'm really pleased to be with you here this morning to discuss the Biden administration's progress on their agenda related to climate change, environmental justice, and their overall environmental agenda. And we've just been through the first 100 days, and much of what has been accomplished was expected and predicted, and the president has made good on many of his campaign promises. According to the American Presidency Project, the president has issued 42 executive orders in his first 100 days, in addition to, and there were other administrative actions, memoranda that were issued as well. And in those 42 orders, he revoked 67 or revised 67 prior executive orders, with many of those revocations, of course, being focused on the EOs that were issued by President Trump. There's been some litigation surrounding those executive orders so far, and based on what's been reported, there have been 21 cases that so far have been filed referring to executive orders in this administration. And compare that to 50 over the first 100 days for President Trump, 10 for President Obama, and 0 for President Bush, George W. Bush. So with those general statistics, they demonstrate there's a clear change of direction in federal policy, and nowhere is that change more clearly demonstrated than in environmental policy. The president kept his campaign promise to re-enter the Paris Agreement. He has canceled the Keystone XL pipeline that was set to bring in additional fossil fuel resources from Canada. There has been a temporary ban issued on new lease sales on federal lands and waters, particularly focused on fossil fuels leasing. And there have been numerous efforts to establish climate and environmental justice across federal decision-making. What I'd like to do is lay out a couple of those, and I won't be able to get to everything and right now, and we'll dive into them in the panel discussion. But just to give you a sense of some of those actions. Of course, the administration started off, like in most all administrations these days, with a regulatory freeze of any non-final regulations from the prior administration. But what was interesting, they also issued a list of actions across every federal agency that were scheduled for review, and no surprise, EPA had the most of any regulations targeted for revisiting or repeal. Some 42 actions, if I recall correctly. The Department of Interior had a number of regulations as well, such as, well, and some have begun work already. And then, of course, the Council on Environmental Quality was tasked with revisiting the NEPA streamlining regulation that was recently finalized. The president issued an executive order on tackling the climate crisis at home and abroad, with setting ambitious goals of a net zero carbon economy by 2050, a carbon-free electricity sector by 2035, and conservation of 30% of all the nation's land and waters, which has come to be known as the 30 by 30 initiative. and then a doubling of offshore wind electric energy production by 2030. The president's also proposed structural reforms based to look at cost-benefit analysis, which is a touchstone of regulatory work since from across many administrations. There's been a publication of a new number known as the social cost of carbon, which has been set as an interim value of $51 per ton, which the federal agencies are supposed to incorporate in their analysis and determining costs and benefits of new federal regulations. And in addition, related to the re-entry into the Paris Agreement, the government has issued what's known as the Nationally Determined Contribution for Greenhouse Gases, which is an attempt, the US's attempt to do their part in ensuring that global average temperatures do not exceed 2 degrees Celsius above pre-industrial levels. So that's where we get the 50 to 52% target for a reduction of greenhouse gas below 2005 levels. As Judge Larson said, every agency, not just the environmental agencies, have been tasked with this goal. And we are, as a nation, trending toward with pretty good reductions. We've already achieved 17% below 2005 levels, and we're on track to achieve 26 to 28% by 2025. But to achieve 50% by 2030 is an ambitious goal, and one of the key elements is to achieve 100% carbon-free electricity production by 2035, which is also very ambitious. We'll talk a lot today about what's happening at the Environmental Protection Agency, and I think this administration, like every administration, will wrestle with a key question, which is how to achieve these goals with the existing statutory and regulatory frameworks that are in place. And of course, how hard to push and how far to push given the current composition of the courts. But just a few of those issues that EPA will focus on are whether to directly regulate GHGs using authorities under the existing Clean Air Act, or whether they may look to more conventional approaches. So for example, direct greenhouse gas regulation is certainly permissible based on and available based on Supreme Court precedent. And the administration will definitely revisit, for example, what's known as the Safe Vehicles Rule for carbon emissions from light duty cars and trucks. But there's a question of maybe relying on more conventional approaches like ratcheting down the national ambient air quality standards to achieve reductions in fossil fuel energy or making it more costly. And that may be an approach that's a little bit more conventional and safer in terms of not overreaching the agency's statutory authority. So I will end it there for now and look forward to discussing these and other issues with my co-panelists.
Hannah, I believe we will now hear from you.
Yes. Thank you. And I appreciate the invitation to be here today to talk about what is a session that could take us all day if we really wanted to sit around and do that. Matt gave some good introduction to what we're seeing from the Biden administration. As Judge Larson mentioned, I'm at the Harvard Law School's Environmental and Energy Law program. And one of the things we've been doing over the last few years is tracking and analyzing federal regulatory developments in the environmental and climate space. So one of the things that I'll talk a little bit more about sort of what we've seen that's different in this administration from the last, and also touch on some of the more specifics that came out of the executive orders and on the environmental justice priorities for this administration. So, we saw a real effort to focus on deregulation across the board in the last administration, and also some reworking of internal operations at environmental agencies. I think you could say that both the Trump administration and the Biden administration have a pretty ambitious program for environmental regulation, but they're just sort of pointed in different directions. And the ambition of the Trump administration's approach was, I think, apparent in how it used rulemaking to sort of reassess and reinterpret the approaches that the environmental agencies had taken before, and their understanding of the Clean Air Act in particular, and in ways that could have limited future efforts to address greenhouse gases through regulatory action. Some of this work was left a little bit unfinished because it didn't quite get through the full stages of litigation, and we've seen some, action at federal courts on a few of those rules, like the ACE rule that, kind of broke with the administration's approach. But these efforts, I point them out just to note that they're going to continue to be relevant, because many of the arguments that were sort of put forth on how to interpret these different provisions of the Clean Air Act, and Matt sort of spoke to a few of those in his opening remarks, will reappear in challenges, I think, to the Biden administration rules. So what has the Biden administration done? They, as Matt outlined, some of their really ambitious climate goals. They've really made incorporating climate change considerations into government decision-making across the board a top priority. And they're considering both the impact of government action on climate change, as well as climate change's impact on public and private actors. And I think this is a little different than what we've seen in some prior administrations. They're trying to be much less reliant on EPA. While there's certainly always going to be a big role for that agency, they're not fully relying on EPA to do all the work. We've seen in their early directives, they're a focus on building the systems to properly or more effectively evaluate and incorporate climate change information into government decision-making processes. And I think you could almost look at this as that the federal government sort of starting to do what investors have been asking companies that they invest in to do over the last 10 years. At the same time, the president has made a point to acknowledge and address inequitable impacts of past governmental action. This is their focus on environmental justice, and they're really trying to ensure equity considerations are given attention in their new ambitions and in their efforts to address climate, as well as in their regulation and enforcement efforts, and in their funding and permitting decisions. So the goal really is not to exacerbate these inequities, but start to correct them. So one of the early executive orders in the first week of the Biden administration focused specifically on advancing racial equity. And I just want to highlight a few things about their efforts so far. One is this, you hear the president speak regularly on the whole of government approach and everyone in his administration. And I think it's notable. There are some real indications that this is how they're approaching things. They've asked agencies to create equity plans. They've launched what they're calling a Justice 40 initiative, and that has a goal to direct 40% of the benefits of relevant federal investments into disadvantaged communities. We don't really know what that is going to look like yet. OMB is developing agency guidance on implementation, but this government-wide approach does differ, I think, from the Obama administration, where the EJ efforts were largely limited to the Environmental Protection Agency. I think another notable feature of their efforts is their personnel. They're bringing in people who have experience in working on equity issues in the environmental space into new positions. They've created new advisory bodies as well, but they're also bringing them into existing posts where they're sort of expected to bring their background knowledge in this equity work into the existing functions of different agencies. And one of the possibly the most notable difference in their environmental justice approach is that there's a real focus on correcting a legacy of disinvestment in communities through direct investment, not just on enhancing participation. So, improving access to participation mechanisms and emphasizing enforcement are certainly key features of any effort to address these problems. But they really are looking through their Justice 40 initiatives and from some of the announcements we've already seen out of agencies on their funding parameters and priorities to really direct investment into communities who have sort of been on haven't been on the receiving end of it in the past. And they're also building, the last thing I'll mention on the EJ issue is that they're building better tools to inform these decisions. They're leading an effort to update the EJ Screen tool so that they can incorporate a broader range of information into their decision-making process. So going back to these early executive orders, Matt talked about the large number of executive orders. I'm going to speak specifically to just a few of them. There were 6 executive orders that were signed in the first week that I think are particularly relevant to our discussion, and they outlined actions that the president wanted executive branch agencies and offices to take on the environment, public health, climate change, and equity. And many of these came with deadlines. So one of the things that my shop has been doing is sort of trying to tease out the deadlines that were in these orders and track what we've seen happen so far. In the administration, we have a very complicated spreadsheet available on our website to do that if you're interested in following along with us. And some of these were focused on planning for future action, requiring submission of new reports and plans, but they also had specific directions to reevaluate prior regulatory action. In addition to the list of 104 agency actions that Matt mentioned that were in a memo that accompanied these EOs, they had some particular rules that were outlined in the text of the EOs that had deadlines for review attached to them. But even the planning pieces are connected to specific goals and actions, and so they're sort of the first step to more direct action. In their first week, there were also 2 presidential memoranda on regulatory review and scientific integrity that are important. And Matt also mentioned the Paris Accord statement. So these have kicked off a flurry of activity. I think it's notable to the extent, for the extent to which the administration really seemed to have come in and worked out its priorities before taking office, to have these lists of prioritized rules they wanted to look at and sort of kick off this effort from the very beginning. One of these executive orders was signed the first day President Biden was in office. And it's also notable for the range of offices and agencies involved. Of course, EPA and DOI are key players in this, but they're not looking to them to carry the water alone. And the directives, particularly the ones that aren't focused on reevaluating prior action, but are more forward-looking, cover all agencies. And there's a lot of emphasis on DOT and DOE as well, and of course, many offices within the White House purview. We've already seen a lot of action, and I think it's notable also that these early efforts seem to outline a detailed agenda beyond reconsideration of the Trump administration's actions. So the regulatory review is a significant portion of the work, but it's not what it's all about. And the reports requested, working groups created, goals established show that they intend to make a lasting mark on environmental and climate policy as a whole. And I'll just finish with making note that the whole of government approach is not limited to the agencies that are most directly under the purview of the president. We're seeing a lot of action at the independent agencies as well. These aren't directly discussed in the executive orders, but particularly at the SEC, with new leadership, we're seeing new priorities. Under the last commissioner of the SEC, there was a lot of pushback against the increasing calls to provide additional guidance on incorporating climate change into corporate disclosure and other activities under the commission's purview. But just in the first couple of months of new leadership at the commission, we've seen a tremendous amount of activity. CorpFin, enforcement, and examinations divisions have all prioritized climate change in their work and explained how they're going to do so over the next year or so. The SEC is expected to update its 22 guidance on climate-related disclosure, and they're doing more to look behind corporate disclosures to understand companies' materiality determinations. And then, of course, they're also talking about potential new requirements and new disclosure requirements that are specific to climate change. They have a comment period that's open right now to gather initial information. But there's a lot that SEC can do and seems prepared to do based on what they've said, the actions so far, even without new regulation. And it's not just the SEC. We're also seeing this in other federal financial regulators. Their new positions, task force and commissions at the Federal Reserve, Treasury, CFTC, that are focused on climate-related risks. Now, some of this was already happening. The Federal Reserve and CFTC were actively, researching and considering the financial system impacts of climate change even before this shift in our political leadership. But I think it's important to note that we're really sort of moving beyond a period in which these discussions largely took place between investors and companies and banks and financial entities to one that's really centered around regulatory actors. And so with that, I will wrap up and pass it to Tony.
Great. Thank you, Hannah. We will now hear from Tony Francois.
Thank you, Judge Larson, and thank you to the Federalist Society for hosting this panel. My name is Tony Francois. I'm a senior attorney with Pacific Legal Foundation, where I primarily represent clients against federal agencies in constitutional and other disputes arising under various federal environmental laws. My remarks this morning address the topic of environmental justice from the perspective of how various federal regulatory regimes impair state and federal common law remedies that are otherwise available to those whose health and homes can be harmed by industrial pollution. Many federal environmental laws have had the consequence, perhaps unintended, of limiting those legal remedies. The key example I'll use this morning is CERCLA, or the Comprehensive Environmental Response Cleanup and Liability Act. CERCLA authorizes the EPA to identify parties potentially responsible for contaminated sites and to order that those parties engage in specified remedial actions to clean up those sites. CERCLA reflects a congressional priority on ensuring diligent cleanup of contaminated sites by those most able to fund the work, the so-called deep pocket, whether or not they're the most immediate cause of the pollution or most recent or current owner of the property that's polluted. CERCLA elevates this priority over complete judicial adjudication of which parties are responsible and to what extent. So it's an example of a regime which advances remedy to the front of the process and leaves determination and apportionment of liability largely to later stages. CERCLA also expresses this priority by barring lawsuits in federal court which challenge EPA's prescribed method of cleanup for a particular site before that cleanup is completed. And that's in 42 United States Code, Section 9613H, which I'll refer to as Section 113H. So I'm going to talk a little bit about an 11th Circuit decision that interprets Section 1113H in the context of constitutional challenges to EPA cleanup plans. In Broward Gardens Tenants Association versus US EPA, the 11th Circuit held in 2002 that the Section 113H bar on judicial review of removal and remediation plans applies to discrimination-based constitutional challenges. In this case, a predominantly African-American group of residents of a public apartment complex next to a city-operated landfill in Fort Lauderdale, Florida, sued EPA and the city to challenge the manner of an EPA-ordered and approved cleanup of that landfill. And the problem they had with the cleanup was that, in their view, backed up by their evidence, it did not actually completely clean up the site and left them exposed to various harmful chemicals. Their complaint in federal court alleged that the public housing project was established as part of an overall plan to racially segregate Fort Lauderdale, that the cleanup plan was inadequate and would leave the plaintiffs exposed to continuing unsafe levels of dioxin and arsenic, and that the execution of the cleanup as ordered would perpetuate de jure segregation. So this is their claim. The complaint pled causes of action for violations of the 5th, 13th, and 14th Amendment as well as Title VI of the Civil Rights Act of 1964. The trial court dismissed all of their claims under Section 113H, which again bars challenges to any ongoing cleanup action. On appeal, the tenants argued to the 11th Circuit that Section 113H does not apply to constitutional claims. The 11th Circuit disagreed. The court first rejected an argument that Section 113H should be read as only applying to cases brought by potentially responsible parties. The theory being that the congressional concern for rapid funding of the cleanup and accomplishment of the cleanup and the bar on judicial challenges that relates to that has the purpose of ensuring that the potentially responsible parties can't delay cleanup through litigation, not that injured parties not be able to delay litigation in order to get a better cleanup. The 11th Circuit noted correctly, I would say, that the plain text of the statute does not make this distinction and can't be read to, that distinction can't be read into it. Instead, the 11th Circuit adopted a plain reading of the term any in Section 113H and concluded that the unlimited breadth of the prohibition encompasses any legal basis for challenge, constitutional or otherwise. The 11th Circuit then examined Supreme Court precedent to determine that there is sufficiently clear congressional intent to bar constitutional claims simply from the term any challenge may not be brought in federal court, or any suit is the word in the statute. So the Broward Garden tenants decision relies on similar holdings from the 6th Circuit in a case called Barmet Aluminum versus Riley, as well as the Eastern District of Michigan in a case called South Macomb Disposal Authority versus EPA. The 11th Circuit, though, did note contrary decisions from the District of West Virginia in Reeves Brothers versus EPA, as well as an unpublished decision in a case called Washington Park Lead Committee versus EPA. In that case, residents of a predominantly African-American public housing project were held to have standing to sue EPA for discrimination and continued segregation, following EPA's decision in a CERCLA action to relocate the residents of privately owned housing from the area immediately surrounding a contaminated site, but not the residents of the public housing project. So that's an unpublished decision from the Eastern District of Virginia in 1998. So Broward Gardens tenants looks at these disparate chains of authority, goes with those cases that find no jurisdiction to hear constitutional challenges to cleanup orders. The court rejected an absurd results canon application from the tenants. The tenants' argument is pretty common sense, really, that the point of CERCLA is to get effective cleanups quickly and well funded. And, it just doesn't, it's kind of an absurd result to say that the people injured by the contaminated site cannot then challenge a cleanup which would leave them in that state of injury. And the court rejected that. The 11th Circuit in Broward Gardens tenants does acknowledge the tension here between a policy of protecting human health through cleanup of toxic sites and preventing legal challenges to cleanups which threaten harm to human health. But the court concluded that the ability to challenge a cleanup after it was complete and the site closed by EPA and to pursue state court nuisance actions resolved this tension. So alongside of the Broward Gardens Tenants Association case, there are a number of other circuits that have held in a more limited setting that potentially responsible parties can bring constitutional due process challenges to, if not an ongoing cleanup, to the overall structure of CERCLA on the due process argument that this advancing of liability in front of, of remedy in front of liability violates the due process rights of the potentially responsible party. So these two lines of authority sit next to each other, somewhat in tension, and raise a question whether other circuits would follow Broward Garden tenants and hold the same way that discrimination-based constitutional claims may not be raised against ongoing EPA cleanup operations. It would make a fairly significant difference, I would say, in how those cleanups are administered, and how the plans are developed, if these kinds of discrimination-based constitutional claims can be brought before the cleanup is complete. So other circuits have yet to weigh in on that. In that sense, Broward Garden tenants is a little bit of an outlier. And of course, Congress has control of the text of its statutes and, could take action in this area as well. And with that, I will hand the mic off to Nadira Clark, our next panelist.
Thank you so much. And it's really nice to be here. It's big shoes to stand in for John Cruden, who's been a wonderful mentor of mine throughout my career. And we wish him and his family the best. I thought that maybe for purposes of my presentation today, that we would think a little bit about sort of environmental justice, the administration's commitment to environmental justice, and really the question that I think is on a lot of my clients' minds, which is sort of what's going to be different? Will anything be different? Will it stick, so to speak? I think a lot of the comments that we've had, here today on the panel sort of raise those questions. There's clearly sort of an absence of law in this area. There's real tension on whether or not you can use existing statutes and regulations to further the government's commitment to environmental justice. And I think there's also a question about, notwithstanding sort of from the sort of leadership of this administration, at the end of the day, the question is sort of despite the commitment, what will be different and will anything be different? And so I thought it might be just interesting to reflect back for a moment on what would ultimately be, how environmental justice started. When I started at the Department of Justice, actually, it was under President Clinton. Environmental justice was just being introduced at the department. And there was a lot of energy and sort of at least lip service around the concept of environmental justice. Certainly the executive order was signed during that time. And you saw within the Department of Justice a real challenge in terms of, I think people, career lawyers who are committed to environmental enforcement, trying to understand what to do with this concept, and a lot of debate going back and forth about, sort of what laws could be used to further this concept. Was it the role of the Environment and Natural Resources Division? Was it the role of the Civil Rights Division? And, I spent probably more time than I cared to remember in meetings where everyone was sort of tied up in knots trying to answer these questions. And I think at the end of the day, while there were some important sort of advancements just in terms of broad commitments, and some infrastructure built within the government, federal government, around environmental justice, I think at the end of the day, there weren't, I think probably from community activist perspective, there weren't necessarily tremendous advancements that were made. And, I think in the Obama administration, it's not tremendously different. I wasn't at the Department of Justice at that time, but, I think you heard commitments, you heard Administrator McCarthy at one point sort of making the connection between climate change and environmental justice and noting the opportunities that presented. But I think if you were to speak to, community activists, I think they would say even under the Obama administration that there was relative little, that the concerns around sort of disparate impact remained. And so, and then for companies and regulated industry, the question is, will this be different, and what will be different? And I think that one thing to consider is just that you have these broad pronouncements that Hannah has mentioned in terms of what the government is committed to. And I'm going to go through some of those as well in a little bit of detail. And so that's notable because the administration is talking about environmental justice in a slightly different way. But I think what's important to recognize as well is sort of kind of the social climate in which this is coming up. Because at the end of the day, given the murkiness of, sort of what the legal sort of framework is for environmental justice, it's going to come down, I think, ultimately to sort of using existing laws, if the government is so inclined to do so, and exercise of discretion. And, I spend most of my career defending criminal actions in environmental and major accidents, and discretion plays a very significant role. And so, I think the question will be how does, given what's happened, and if we just sit back for a moment and think whether we agree or disagree about sort of the events that have transpired over the last year, the reality is there has been a pandemic, and there has been a significant amount of sort of racial strife and focus on racial equity. And there's been a connection made, it seems, by community groups with the idea that there's sort of this connection between sort of vulnerability to COVID-19 and sort of the collective impact over the years of environmental pollution. And so I think you see within sort of certain sectors of society a real focus on that. And I think you see that within the administration as well. So I guess when I say all of that, I think part of the point I would make is that, will there be a difference? There may very well be a difference, not just because the government is thinking and talking about environmental justice differently, but also because I think individuals, there's a demand, sort of a climate and a demand by the public. There's a sense, even by companies and regulated industry, that there's a need to at least appear to be sensitive to issues of racial equity. And with that climate, I think you're going to see some, at least, use of discretion under traditional environmental laws in favor of protecting or bringing cases where, minority and low-income communities are perceived to be disproportionately impacted. And, I think we all know that, or we recognize that maybe there is that out there. But I think, having spent a fair amount of time in the Department of Justice, it's important to recognize that when there's a climate like that, that really does impact what cases are selected and the vigor with which they're pursued. And I think that will make a real difference. I just wanted to touch on just some of the things, at the risk of repeating some of what Hannah said. I wanted to just touch on just some of the things that I thought are notable about the Biden administration's focus on environmental justice. When we talk about the whole of government, it's really sort of this intersectional environmentalism, and the concept that environment justice, climate justice, and racial justice and social justice are tied together, and that they can't be seen in isolation. And if that's the concept, then you see that it's going to impact, as we've said, all of government and all agencies. We've noted a few of the developments, but I think certainly watching the White House Environmental Justice Interagency Council and looking at what some of the developments will be there will be important in terms of seeing sort of what happens with environmental justice. I think watching as well the developments within the Council on Environmental Quality and looking at some of the developments there will be important as well. I also think that it will be important to consider, to my point about enforcement, there's a real focus, as Hannah mentioned, on sort of collection of data. And we're observing that quite a bit in my own work in negotiating resolutions with the agencies, including EPA. There's a keen interest in fence line data and collecting that data and in sort of slicing it and dicing it in a number of different manners. That's obviously groundwork, or presumably groundwork, for bringing enforcement actions. And I think that will lead to marked changes potentially in the types of enforcement that is brought. I wanted to mention just two other things that I think are interesting, and this has already been touched on a bit. One is the SEC enforcement. The SEC launched a new climate and environmental and ESG task force, and that's likely to drive new initiatives. The Commission's focus will include environmental disclosures, diversity disclosures at the board and workforce levels, and political spending disclosures. The SEC also recently completed a review of ESG investing and issued a risk alert based on increasing numbers of ESG products and services that don't have a standardized definition or industry practice. And I think that emphasis on public statements is especially important. And you will see, I think, the focus on potentially misleading statements and omissions, and the focus on climate change that could easily sort of move to environmental justice. And so, why is that important? I think as companies think about the reality, react to this focus on environmental justice, to the extent that there is a tendency to start to build a program, start to characterize actions as being, responsive to concerns around environmental justice. I think there's a recognition, the SEC will be evaluating that and testing that to some degree. And I think that is where you see sort of, a unique approach outside of EPA to, I think, Matt's earlier point, that it's not just relying on EPA. And then similarly with the FTC, I think you see with the FTC and the green guides, there's a focus there sort of more from the perspective of consumer protection or deceptive marketing. Same kind of concept though, sort of representations. There's a focus on environmental justice, there's a great desire, I think, by companies to see that as an opportunity for promotion of products, services, the overall ethos of the company. But there too, I think there'll be some testing of that by the FTC. So I think in closing, I would just say that discretion is important. We know that, but it's particularly true in the context of environmental justice. And I think when you consider the climate that we're in, the imperative that many feel about sort of speaking to the issue of racial disparity or injustice, I think that indeed we may see this administration making some advances that we haven't seen before, notwithstanding sort of the absence of real sort of legal construct to rely on. Thank you, and I'll turn it back to Judge Larson.
Thank you to all of our speakers so far this morning. Your comments have certainly provoked a lot of questions in my mind. And I'm sure that you would like to have a chance to speak to one another and respond maybe to a few things that have been said. So I think I will give the speakers an opportunity now to offer any comments sort of in response to what other speakers have said. since we're not sitting around a table, I feel like I can't be quite as organic as I ordinarily would. So I'll sort of go in order and ask if anyone would like to make any comments in response to others. So I will start with Matt Leopold and see if you have anything you wanna chime in on.
Thanks, Judge. I wanted to make the point, Nadir's comments about discretion in the agencies, I think is particularly relevant. And, having recently served, that it's very true that the federal agencies have vast scopes of discretion, even within the limits that are, put in our federal environmental laws and other laws. And with respect to environmental justice and the question of how do they accomplish the policy goals, I think enforcement in particular is the one area which is wholly driven by discretion to some extent. That, there are many violations, many referrals from states around the country, and the federal government is large, but it doesn't have unlimited resources. There are about 400 attorneys at the Department of Justice, Environment and Natural Resources Division, and of those, the majority are enforcement based, but not all of them. And so, how to utilize that federal resource and where to focus it, and is a key issue that I've been hearing, from DOJ. And in watching the types of cases EPA is choosing to prioritize and bring themselves or refer to the Justice Department, I think will be focused around those communities in proximity to pollution, as it should be, and mitigating risks posed by pollution, in particular air pollution. Is a big focus. But as Tony mentioned, site cleanup is also an issue that often plagues low-income and minority communities. And I think you'll see in that context, CERCLA's mechanisms, where Tony's very right that 113H is routinely asserted by the government to stop individuals from thwarting an EPA remedial plan. But you may see on the front end, the administrative process, EPA reaching out more broadly to impacted communities as they design their cleanup program and remedial measures. You've seen in some of the policy documents, EPA and the White House calling for more engagement and transparency in mechanisms like the remedial investigation and feasibility studies that are done before the government makes a determination on a CERCLA remedy. So those are a couple thoughts in response to the comments.
Great. Hannah, do you have anything you want to chime in about?
Sure. I think one thing that you can hear from listening to us all speak about different pieces. Sorry, I thought I hit it. I was going to say that one of the things that's apparent from listening to all of us speak about this is that a lot of what we're seeing from the administration, what may move the needle on some of their priorities, really is about process. It's about incorporating information into the decision-making process, both on their climate initiatives and on their environmental justice focus. And you're seeing, both of the, as Nadir mentioned, the sort of request for information and incorporation of information into the agency's work being a priority on the EJ issues, but also the structure we've seen that's come out of the executive orders. And I'm looking ahead a little bit to one of the questions I see in the queue here on the Modernizing Regulatory Review memo. That's also sort of another process memo, right? It's not necessarily directing agencies to ensure that their initiatives don't have EJ impacts. It's directing agencies to incorporate the consideration of these impacts into their decision-making process. And kind of playing back to what Matt said on discretion, much of the law, or administrative law and environmental regulatory rulemaking is very much focused on what you consider. What is, that's what NEPA is about. That's what EPA is about, and a good portion of it. And I apologize if you're picking up background noise from me. There's some yard work going on near my house.
I think we might be getting a little feedback from you, Hannah. So not just the yard work, but so maybe we should move just so we can hear better, and maybe that'll get fixed. And I think move to Tony Francois. We will come back to you, Hannah. I promise to let you have your time.
Yeah, thank you, Judge Larson. Responding to the comments that both Nadira and Matt made about agency discretion and their ability, really I'd say their responsibility to front load, making sure that the injured parties at the very least are made whole in the cleanup process. I don't know what I guess what I'll say is that somehow or other that needs to be more than just a matter of agency discretion. And it's not meant as a criticism of the fact that the agency makes a higher priority of that. That's not what I mean. But that as the injured parties, somehow or other, I think, whether that's judicial interpretation of 113H or amendment of it or some other change to the status quo, somehow or other, the injured parties need to be able to have, I think, a little bit more time in the driver's seat to make sure that their the impacts to them and their property aren't left behind for the duration of a cleanup. I mean, I think everybody knows, I mean, the cleanups take a very long time to do in most cases. I think the last administration, one of its most admirable things was the priority it put on accelerating cleanups and getting them done and getting sites closed. And, but even with that, I mean, people have to live with a problem for a long time. And so I don't really know what the answer to that is, because the 113H sort of disposition of these things is pretty long standing, and there's a lot of reliance expectation on it. I'm not sure, what the wisdom of simply changing that would be by amending the statute. But I do tend to think that there would be value in some more control over the outcomes for the actually injured parties, and that probably should rest on more than the good actions of the agencies.
Okay. Hannah, are we back? Are we back to you?
Well, let's test this out. Does it sound okay?
Well, still getting some feedback. I don't know what's going on. I think we'll go to Nadira, and then maybe we can circle back one more time.
Well, I had the benefit of going last, so I sort of addressed many of the comments. I mean, I think I would just say that when we are talking about agency discretion, there's a real education, I think, that has to take place. I mean, I think everybody in government is well-meaning, but I think for a long time and it's not intentional, but I think it just happens that we focus on certain sort of areas of concern and interest, and others, without even thinking about it, we dismiss. I don't know that this is really responsive to what anyone else has said, but I just make the comment that sort of even with discretion, even with this sort of imperative that people may feel right now, I think there's it will take a certain amount of education and development for, even with all of that, for individuals who have been disparately impacted in the past to have their interests heard. And I think whatever changes might take place, perhaps to Tony's point, I think we have to recognize that it's not natural for people. these interests and these concerns and the impacts that people are experiencing are things that we just haven't had an opportunity to consider. And I think now is the time that people are going to focus on it.
Okay, so I understand that the tech people are reaching out to Hannah to try and fix whatever problem we have on her end. But I had a few questions. It seems to me that one of the things that we've been talking about is less reliance on the EPA and more reliance on other agencies to carry an environmental brief, whether that be environmental justice or also climate change. And of course, those are related. And I imagine other environmental concerns as well. Many of us have spent time in government, and when you disperse regulatory authority or litigation authority across numerous agencies, or even when you put it in different hands within a same agency, that often leads to conflicts. So I guess one question I have is whether dispersing all of this authority over these questions will result in more action or less action. Do any of you have any thoughts on that question?
I'll be happy to kick it off. I think, Judge, you've rightly recognized a challenge in kind of wielding federal power. By design, I think it's been separated by Congress into different agencies. The most notorious example of that, even that I think President Obama mentioned in one of his State of the Union speeches, is the ability one agency, the Fish and Wildlife Service, regulates endangered species that are terrestrial. Another agency in the Department of Commerce, the National Marine Fisheries Service, regulates the same fish when they go out into the ocean. The wisdom of that and why Congress separated that authority into two agencies, which often conflict, and then puts the Justice Department in interesting situations, sometimes in court. I don't necessarily understand, but when it comes to harnessing all the agencies and getting them rowing in one direction, that is where the power of the executive order really comes into play. And what I would note is this trend towards more aggressive use of executive actions is really been, Biden wasn't the first president to lean into that. I think it's becoming more of a recognized practice that administrations on day one come in with pre-drafted, ready, pre-packaged executive orders to make sure that they are getting their policies out and in the bloodstream of the federal agencies. And in addition to that, on climate in particular, this administration has appointed not one, but two climate czars. Gina McCarthy, the former administrator of the Environmental Protection Agency, to focus on domestic issues, and former Secretary of State John Kerry to focus on global climate change issues in the international space.
All right, I'm here.
Great, Hannah, we're glad to have you back.
Yeah,
Sorry about that.
Matt, I didn't mean to cut you off though. Did you want to conclude there?
Yeah, just to point out that I think that this administration on climate change and environmental justice as well is clearly running the policy from the White House, and I think that's going to eliminate some of the usual conflicts and turf wars among federal agencies.
Great. Hannah, I don't know if you heard the question, but the question was, which I think Matt addressed well, was whether dispersing regulatory authority among agencies is likely to lead to more to progress or to conflict, because agencies with different ideas about how to enforce the same statute or pursue the same regulatory goals may end up in turf wars or battles. I don't know if you want to comment on that or whether we want to move to some of the speakers in the queue, but I want to give you a chance since you've been off screen for a little bit.
Sorry, yes, I apologize for the technical difficulties. I hope you can hear me well now. I think that actually kind of connects well with what I was attempting to say earlier, which is that, part of what will make that successful for them is if they are able to integrate new decision-making processes into their efforts, right? So a lot of the focus we've seen in some of these early EOs and some of the memos, the regulatory review memo, for example, and others, is how are they getting environmental justice information, climate-related information into the regular decision-making process of many functions of government. And I think that's less about, what does the statute allow and where. It's more, we make these decisions within our purview. How does this information relate to the decisions and the authority we already have? And how should we be considering that in our work? And so I think that's sort of a complement to what Matt was talking about as far as the coordination from the White House. I did hear a little bit of that. But I think they will be more successful if they're able to develop the tools to really to evaluate these issues. That's why I think you see a focus on things like the revamp of EJ Screen and the social cost of carbon and sort of reevaluating how they're approaching cost benefit analysis and those types of rulemaking and decision-making tools, and getting that throughout the government outside of maybe the particular places where we're used to talking about them.
We have a question in the queue that is related, and so I think I'll pose it now for the group, which is assuming, for the sake of argument, the latitude to do environmental justice in non-environmentally related or specifically environmentally related agencies. Do we have any concerns about the adequacy of environmental expertise at these agencies among the top leadership at HHS or DOT or the Department of Justice? Are we concerned that expertise may not be present in those agencies and we may end up with something that's less than ideal? Any of our speakers want to address that? I'll just let you jump up.
I'll take a run at that. I think that there's even a bigger question with that. I mean, obviously, agencies that do not primarily enforce environmental statutes can still, have people within the secretary's office or sub-agency leadership offices that have that expertise. And, you can create positions within non-environmental agencies to supply the agency with some environmental expertise, just the same way that, EPA can, by having positions that are dedicated to things like, understanding the financial aspects of cleanups or, other, permitting, things like that, can spin up on those things. I think there's kind of a bigger question that this is really just one example of, which is this the way the government is supposed to work? I think the high school civics version of the federal government, which is might state it a little bit pejoratively, but is of great interest to pretty much everybody involved with the Federalist Society, is that the constitutional settlement of this question is that Congress makes the rules and decides what the agencies are going to do, and the agencies do that, and that even in an era of congressional abdication where so many policy questions are delegated to the executive branch and to the agencies, the fact that that statutes drive the workflow, the workload for agencies, is an integral part of the process of congressional oversight. I mean, what the committees meet on and what they grill agency staff and leadership on is really all designed around, what are the statutes that agent and the programs that agency and that part of the agency is supposed to be implementing. When you broadly replace that with kind of legislator-in-chief executive order governance from the White House, one of the things that does is frustrates the typical methodology, as underperforming as it may be at times, of congressional oversight. Because if the answer to a committee chair from an agency head is, why aren't you doing these things? If the answer to that is because the president has me doing something different, Congress is in a different position than they would be if the answer is, I just didn't get around to it. I know that's what I'm supposed to be doing. I just haven't done it, or haven't done it well. And so there's a lot of things contributing to this. It's it's much broader than this topic or even this presidency, obviously. But I think it's important for all of us to observe this as it happens, that there's a pretty substantial sort of change in paradigm about the way the executive branch operates that we're observing here.
Okay, I think I might go to a few of the questions that we have in our queue. I think Hannah already addressed this question regarding Biden's memo, modernizing regulatory review, and explained. So the question was that this memo, modernizing regulatory review, directs agencies to ensure that regulatory initiatives do not have environmental justice impacts, but environmental regulations routinely have such impacts, and how can that be reconciled? I think Hannah already addressed that question, but we have a follow-up, I don't know if it's a question or a statement, regarding section 2 of that memo that directs OMB to write recommendations on environmental justice analysis. And so maybe some of the panelists want to comment on that and explain what that might look like. Is anyone familiar with what OMB's brief is here and how that might affect the conversation? Hannah, is that something that you're familiar with?
Yeah, I was just going back to take another look at it. So my understanding of that memo is it is more of a process and analysis memo about how to approach, it kind of goes back to Circular A4 and talks about regulatory analysis. And I think the directive there is to require more, more direct consideration of environmental justice issues in the analysis. And yes, OMB is part of that as their sort of oversight of regulatory, the development of rules and how these types of cross-cutting initiatives are applied across agencies in providing some guidance there, just as they are with the environmental justice, Justice 40 initiative and developing some implementing guidelines for agencies. So I think we're still sort of waiting to see what these directives are going to result in and what they will mean for the actual process that agencies go through when they develop their rulemakings. But I think we're going to see new guidance on, how to incorporate environmental justice information into their process and what type of information they need to be considering. We are already seeing some a more focus on EJ issues or just sort of highlighting of the EJ considerations in rulemakings with the HFC rule proposal that came out. That was sort of highlighted a little more than you would normally see by bringing it to the forefront. A lot of times the environmental justice considerations are sort of buried down in the rulemaking. But I don't think that's yet where they're going. We're going to see more action with more guidance and recommendations as to more specifically how they expect agencies to consider these issues.
So We have another question in the queue, which might be related, although I'm not sure. The question is whether anyone in the panel is familiar with the 2021 IEA Cleanup Energy Transition Report. Does anybody have any comments on that particular energy transition report, or want to offer some clarifications on that? If not, it might be just something that's not in our particular panel's wheelhouse. There's been a lot of stuff coming out of this new administration. So, but maybe Hannah has an answer.
Well, I could just, I know the IEA has recently put out a new report. I think this is the one that they're referring to that was focused on more aggressive action, sort of highlighting the need for more aggressive action on decarbonization in order to reach the goals that have been set. But I can't say that I have a lot of detailed information on it. The other piece of the question that's mentioned is the demand for critical minerals. That is a significant issue that anybody focusing on renewables has to consider, is sort of what are the other needs for different types of development, whether it's batteries or anything else that requires sort of more, or the PV, solar panels and the like that have different kinds of supply chain needs. And I think that's if I'm reading it correctly, I think that's what this question is asking, is related to. And I think this administration is definitely considering these issues, and you're seeing a lot of activity in DOE around funding initiatives to address concerns around potential shortage in supplies for other, key minerals for different, as these sort of efforts in renewables development ramp up.
I'll just jump in on one point. I've read a little bit about the report, but I think the question gets to the point of, even this week, the president visited Ford's manufacturing plant to talk about a complete transition to electric vehicles from fossil fuel combustion engines. And I think a test of the mettle of this new policy approach really is, where are we going to source those minerals? Are we going to source them? Right now, reports I've read said 80% of the minerals that are needed to create batteries for electric vehicles are coming from China at the moment. Are we going to have a mining renaissance in this country and to help source those, the EVs, and have the ability to produce those domestically? And how are we going to dispose of those batteries is a huge question for environmental law as well. But just on the mining point, it's becoming more and more difficult to permit new mines in this country. And so how are we going to balance natural resource concerns with the EV renewable transition? And I think no one fully knows or appreciates that yet, and the how sourcing those minerals and how whether we're going to allow that to occur in the United States.
Interesting. As a resident of the Detroit metro area, that's what we hear about is the new Ford truck with this giant battery. But it's interesting to think about, how are we going to produce those batteries and where are we going to dispose of them? So anyone else want to comment on that? No, if not, I have another question, which might be directed towards Nadira. I'm not sure anyone could comment, but you mentioned discretion in environmental enforcement, and obviously that plays a huge role. I'm wondering whether what you meant by that is discretion in using existing authorities, sort of, and we might say like within the lines, and just directing it's sort of more conventional prosecutions or enforcement actions towards particular communities. So using conventional authorities in new places, or are you thinking about discretion in terms of a broader and perhaps more creative reading of conventional authorities? So where do you see this discretion going? And I'm not sure if my question is clear, but if you understand it, you could answer it.
I do. Thank you, Judge. I think I initially saw it in terms of sort of discretion in terms of using existing authority. Not to say that we might not get to a place as sort of we evolve and this administration evolves, where you're sort of testing new and creative approaches to existing authority. But I think within existing authority, there's the idea, when I listen to sort of environmental justice activists sort of talk about what they're looking for, it really is just wanting to be considered, the impacts that they're experiencing, the communities that they live in, even just under existing law. And I know, and I think many of us who've worked in government know that even the path that it takes for there to be if you're in environmental enforcement, or you're in environmental crimes, the path that it takes to get sort of folders on your desk of potential cases, there's a lot of discretion involved in sort of who chose what, to focus where, and what information was available, and what resonated with you when you saw, an agent when they saw it, or a regulatory attorney when they saw it. There's lots of steps along the way before you get to the stage that, there's a recommendation for enforcement that's brought at the Department of Justice. And so I'm thinking really just in terms of use of existing laws, but perhaps through some of the guidance that's issued and some of the directives around thinking about environmental justice as being more intentional about thinking about what was that path, what might not have been considered, how might you change your sort of how might those procedures change so that you're sort of viewing more broadly or considering more broadly communities or impacts that you wouldn't otherwise have, but that are certainly already sort of recognized within the law.
Do you think, in your experience as a prosecutor and as an environmental litigator, what do you think have been the roadblocks to the kind of enforcement that environmental communities might want to see, communities adversely affected by environmental concerns?
I think some of it just comes down to, just having, in order to make an effective environmental claim, I think sometimes you just have to have resources, right? You have to be able to articulate. You may perceive that you are experiencing adverse effects from the facility that's, across the street from you, or you may, believe that those are issues, but you have to have more than that in order to bring a case. And so I think some of it is a lack of resources by these community groups and an inability to sort of get adequate legal representation. And I think some of the some of the money that's going to be funneled to these groups may shift that. But I also think it's even when you do that, and once it sort of comes through the system within EPA or the other agencies, reaching all the way up to Justice Department, for instance, on the criminal side, I think that, how a lot of whether you bring a criminal case as a prosecutor has to do with the law, but also how outraged are you? How much does it bother you? How concerned are you about the actions? And you have a lot of discretion within that, right? You're not compelled to bring a case. And whether you choose to either decline that case or, on the criminal side, decline that case or plead that case to something lesser, a lot of that just has to do with kind of your own background and your thinking, and you're not doing it with malice. But perhaps part of being more intentional and asking agencies to think more about this means that you'll think perhaps a little differently about where you might be inclined to decline a case, and perhaps you take a second look. Or when an agent brings you a file, perhaps you ask, sort of what didn't make it into the file. On the criminal side anyway, that's just sort of maybe an example.
Matt or Tony, do either of you want to comment on what this discretion might look like in the new administration? No?
Well, I would defer to Matt on that. I'm not having been in the government, I really would want to hear from those who have been. Matt and I worked on an enforcement matter together when he was at EPA, so that was kind of a one-off. But I guess I started. My experience with enforcement, both civil and criminal, is that there always seems to be something extra beyond. I think this is coherent with Nadira's observation about it. Something beyond simply here's the elements of the crime or here's the elements of civil liability. This person satisfies those elements, we should enforce. There always seems to be something else going on. Prior history with the agency that refers the case, I think, is kind of a typical thing. Or something that the agency appears to have identified as a priority for its field staff to funnel upward for referral to DOJ. And I do tend to think, observing this from the perspective of representing people who are enforced against, that leadership policy on this does make a difference in the types of cases that are brought and that are not brought. And that, Nadira's discussion about education and the kind of policy setting, I think does actually play a large role and certainly can in, bringing certain types of cases and leaving others aside.
I'll add an element that we haven't discussed yet, and for people in the audience who are less familiar with how environmental enforcement cases work, EPA is one of the largest generators, of course, of new cases and matters. And there's an office called the Office of Enforcement and Compliance Assurance that sets enforcement policy. And there are elements like Nadira talked about where individual attorneys, either aggressively pursue cases or not within certain parameters. But there's also formal policymaking at OWECA to formally tell, numerous on a EPA-wide basis, tell the employees and the environmental prosecutors, if you will, which cases are going to be pursued. So a memo was recently issued by the acting head of OWECA that said, you need to identify environmental justice cases for potential, development in the administrative enforcement process, but also for potential referral to the U.S. Department of Justice. Most enforcement cases are handled at the administrative level, and the more serious cases with higher penalties and environmental harm are referred to the DOJ. But that policy has been issued, and it also talks about the tools called next generation enforcement, using data collection, potentially drones, to gather data using the. I know people think the resources of the federal government are unlimited, but they're actually not. And so utilizing technology to gather the data that Hannah was talking about in order to more effectively make those cases. So putting fence line monitors next to a facility that might be exceeding permitted limits of air pollution and affecting an EJ community is a prime example that a lot of people are talking about right now.
Interesting. And when you start talking about things like electronic monitoring and drones, of course, then I can imagine that there will be a number of other new legal issues with respect to privacy concerns that will probably land itself here and in my desk or one of those, one of the other circuits. I see that we are just about out of time. We have about 1 more minute in the panel. So if any of the panelists would like to make a final remark, or there's something that I didn't call on you to speak about before we end, I would offer this remaining minute to any of you. Okay, well, and if not, then I think with 30 seconds left, we can probably conclude. But we aren't going to go just yet. This platform that we're using today, AirMeet, offers us a chance to head to what's called a virtual lounge, where participants can network with other participants and also with any of our panelists who are free to join us. To join the lounge after this session, you will see an alert come up in the right-hand corner of your screen. You can click on that alert, and that will move you to the lounge. And once you're in the lounge, you can click on one of the boxes that appears to join a virtual table. Once you're at the table, you'll need to turn your camera and your mic back on so that you can sit down at the virtual table and have a conversation with each other. So with those directions concluded, I would like to spend the last few minutes just thanking our panel, thanking the Federalist Society for putting on this informative panel and rounding up these distinguished speakers. I also would like to thank the audience for your participation and for the good questions that you submitted to us. If you would like to join our next panel, the next conference event is entitled, "Is Faithful Execution Being Devoured by Factional Execution?" That will begin at 1 o'clock Eastern time, and you can log in for that. But for now, you should stand by for an alert that will direct you into the lounge. Thank you very much to all of our speakers. And I think our business here today is concluded. If I could adjourn court, I would, but I don't have a gavel. So I'll just have to use my voice. Thank you.